Okay, I was trying to record the lecture, so I have started before I remember that I was supposed to make an attempt to record that. Now, we said that Samuel and Duncanson said that in their discussion of theories, said truth is not a criterion we would use. Every reflection is by definition a true reflection. Usefulness is the test of mirror gazing. The device produces information when we use it, which enables us to perform tasks we would otherwise find impossible or more difficult. Now, Prof also explained this to you last week when we were talking about using a mirror. And I said, well, if I'm sure some of our ladies, when they hold a mirror, will probably use it to put on makeup and to see whether they are presentable before they go out. And some of our, there's a guy whose name here is Cool on his display. So I'm assuming when Mr. Cool goes out, he's going to use his mirror to make sure that he looks as cool as humanly possible. Now, that's one purpose for a mirror. But now you have to look at a mirror as a theory. That is one purpose. And we said during the Boko Haram, at the height of Boko Haram bombings, if you go into hotels and you go into maybe federal government establishments and some private establishments, you will see this long stick with a mirror tied to it, and they stick it under your car. Why do they do that?
To check for explosives.
Thank you. To check for explosives. Maybe you've tied a bomb or something under the car and you want to go and blow up a federal building or something. Now, that's another purpose. A third purpose could be, of course, this will probably be prisoners who are talking. One person is in his cell, the second person is in his cell, a third person is in his cell, and then while they are talking, they have these tiny, tiny mirrors that they stick out of their cells so that they can reflect off each other and see who they are talking to. That is yet another purpose. For what? For one mirror. Now, when you look at theories in this manner, what that tells you is that the importance of theories is the purpose that they seek to fulfill. And I also told you that when you go into the schools of jurisprudence, you are going to be seeing certain things. You are going to know when, for example, Jeremy Bentham says, law is anything that the legislature enacts. And he builds a whole lifetime of theories around that. What that means is that each time you think about Jeremy Bentham or about other scholars in the positivist school, because they are all, they follow the same trajectory. Now, when you talk about that, the first thing that comes to your mind is legislation. These scholars are talking about legislation. Most of the things that they will be talking about will be focused on legislation. And in the same manner, when you talk about historical school, you talk about customary law, first and foremost. The importance of their contribution to customary law. What is the nature of customary law? What are the components of customary law? When you talk about customary law, what is customary law in relationship to other things, such as legislation, for example? Now, we're talking about purpose for theories, and these are just two. Then also, when you talk about the realist school, where the realist school said a lot of the things that happen in terms of administration of justice happens in right from investigation from the police to the lawyer's chamber before it even gets to the court. A lot of decision making has been taken care of. Why? Because you are constantly filtering stories. The stories are being filtered before the police who do the investigation. When your client is accused, he gives you a story, some of the filtered story. Then you filter it for the purpose of adjudication in court. So by the time the thing gets to the judge and the judge eventually makes a decision, the decision can be completely different from in relationship to the facts that actually happened. So the realist school also started something which made people to concentrate more in terms of other subcultures. Things that were happening, let me put it in a language here, things that were happening underground, outside of the legal, of our understanding of what the legal system itself is. Then you have the sociological school too. The sociological school also, they have theories relating to things like human morphology, the population, how populations react to law. For example, during depression, we have a pandemic now. How do we react to law in the era of COVID-19? You know, so we will do some of that during our discussion. But what you must also always realize when you look at a theory is don't look at a theory as a universal truth. Look at it in terms of what are the purposes that this particular theory can solve. What are the questions that it answers? And I think it becomes much easier for you to understand all the schools of law as the continuum of the search for knowledge. Now, one of the inquiries in jurisprudence has been the analysis of relationships. And to give you a background of what the analysis of relationships is, we talked about there being a general relationship between citizens and government, what Hugo Grotius calls the social contract theory. And he said there are two levels of the social contract theory. The first one is your internal domestic relationship between citizen and government. And the other level is in international law, the consent between states to have interstate or multilateral relations. Now, we are more focused now on what happens domestically. That is one of the basic inquiries that we try to look at. And the law is seen, and it says the law is seen as giving rights, liberties, claims, while extracting liabilities, etc., from citizens at the same time. Can somebody give us an explanation of what I just said? That the law is seen as giving people rights, liberties, claims, while extracting duties and liabilities. Just unmute your mic and speak. Are you hearing, were you hearing all I've said in the beginning?
Yes, sir.
I thought someone, all of you will also keep quiet so that somebody won't say yes and I'll now say, okay, answer the question I asked. Can someone help us? Hello? Okay, I see it's as if some of you are already forming each other in clusters and using the same system to access lectures.
Yes, sir.
Okay, so Kwajafa, how many are you behind your laptop?
We actually two, but we are not using the same place. We are not using the same system.
Okay, I'm not using the same system, right?
Yes.
Okay, could you help us? We were talking about law is seen as giving rights to people, rights, claims, liberties, while extracting duties and liabilities.
Okay, let me try. So we're first talking about the foundation upon which this stood was the fact that jurisprudence generally tries to analyze relationships in different possible terms. So we can say, and then now we are saying the law is seen to give people rights, liberties, and claims. So if we look at the way our laws are now, or generally the way laws are couched, they see, if you look at chapter 4, let's use our constitution as an example. You look at our constitution, you see different kinds of rights under, say, chapter 4 and even chapter 2. of the Nigerian Constitution. Yet, I think Section 24 of the Constitution is what talks about like the duties of the citizens, because the two have to like be put in balance for everything to function. So the law will give rights and liberties and freedoms, but it also takes into consideration that one person does not make up a society. And for societal benefits as well, people should have certain types of duties and be liable for breach of these duties since the law is regulatory and generally seeks to like maintain order in a way, it must have balance between these two factors.
Thank you very much. Thank you. Now, you basically captured, I think, what we are trying to say here. When you look at law and you look at the relationships with people, now parties in law generally have more or less the same rights and more or less the same duties and liabilities, depending, of course, on where you are coming from. The rights I have as a lecturer, for example, will be almost inverse to the rights that you have as a student. So it's very much like this yin and yang Chinese thing, where you have a hard and soft aspect of everything. Now, the hard aspect, of course, the soft aspect will be, if you are using that same theory for here, will be that you are going to have rights, liberties, and claims. Now, the hard aspect of it is that you are going to, for you to be able to get that, there are certain things that you have to be able to have. I mean, there are certain things that you give off. Some of the things that you give away will be, of course, control. Because it now means that your own duties, if somebody has the right to liberty, it means you also have a duty not to detract from that right to liberty and keep him in false imprisonment. So a lot of these things can basically have a soft and hard, but the law generally, some schools will look at law as the main purpose of law being social control. And if you are looking at the main purpose of law being social control, then obviously what you have in terms of a social contract theory will become much more important in terms of how you think about the relationships between people, because law really is about relationships and what those relationships bring to the table. Now, we said, and then the task of legal inquiry is to introduce clarity into these vague concepts. Some of these vague concepts, like we say, is liberties. When you say liberties, what do you mean by liberties? When you say claims, what's a claim? When you say, for example, right, what is a right? Last week, I told you that I think lawyers are probably the people who don't know what right is more than any other set of people of any persuasion. Because when you go into the streets, the taxi driver will tell you that it is my right to park here. And because he's so sure of what his right to park there is, if you are a jurisprudence student, you'll probably be a little confused as to what exactly does this man mean by right. Because you are filled with doubting as to what exactly the components of rights will be. And then when you say, what is the nature of right? How do you apply rights? What is the eventual purpose for having something called rights? And because you are a law student, you are more confused than the ordinary man on the streets who just looks at right as, well, right. I hope you understand.
Yes, sir.
Yes, sir.
Now, and we also say that the most used concepts are the ones that are impervious to adequate legal analysis. And I'll give you some examples before we even go into what is a legal right and what is not a legal right. When you say somebody, just basic biological terms have changed. We also had this discussion last week, where male is not male as such anymore. where female is not female as such anymore. Where, for example, when you talk in terms of the right to life can be escalated to other things such as right to abortion or right to, and somebody says right to abortion is different because right to, if you say I have a right to abortion, it also means that I have a right to self-dignity because I control my body. I can make a decision as to what to do about my body and what not to do about my body. Obviously, there's a third party there who is probably a fetus in the body, and then you have all those kinds of discussion. Now, in terms of having a legal right, we have three scenarios here. We say A strikes B without provocation. Does A have a legal right? Does B have a legal right if he has a legal right? What are those rights? A strikes B, fearing for his safety after a verbal assault. Who has what rights? If B has a right, could that right actually be a privilege and not a right? The third scenario, we say A writes a will, devolving all his property to his youngest son. What are the rights there? So when we talk about theories, we are talking about theories that come from the background of context. What is the context behind these facts? What is happening? The third one, for example, under your regular Wills Act, A will probably have a right to devolve all his property to anybody he wants to. Obviously, in the UK and some other countries, there are minimum requirements for you to provide for people that you leave behind, but those minimums are so negligible that they amount to almost nothing. Now, in Nigeria here, if, for example, you are a Muslim, will you have a right to devolve a will, to use a will devolving all your property to your youngest son?
No, sir.
Thank you. Why? Because you are a Muslim. If you are not a Muslim, you will probably have that right. So everything that we talk about comes from the background of context. What is the context with which we are discussing? Which is why a lot of times when people ask you questions as a lawyer, there is no shame in it to say, I'll get back to you, give me a couple of days to think about it. Why? Because you need an inquiry into the context before you can. We'll talk about some of these things about theories traveling well. When you make a theory, you want the theory to travel well, to encompass as many facts as possible. Now, I will say, while it will seem B in the first instance will have a right against A for the assault, A in the second instance has at best a privilege disguised as a legal right. In the last instance, A will seem to have a clear right to dispose his property as he is the owner of the property. But like we have said again, when you look at the context, this is not a very clear statement of the law if, for example, he were a Muslim. And in all these circumstances, right is the same. Right hasn't changed. But what right has done is that it has different colorations. And those colorations we must all access and then analyze. The important thing is to know that all three rights have an advantageous right, capable of, if not enforcement, then recognition. Any comments so far?
Good morning, sir.
Good morning. How are you?
Yeah, I'm fine, sir. So I want you to maybe give an explanation. Why exactly is? Can you go back to the previous slides, please, sir?
Okay.
Okay.
Okay?
So why exactly would? Yes, sir. Yes, sir. Why exactly would A have at best a privilege disguised as a legal right in the second instance, sir?
A was fearing for his safety. Ordinarily, he does not have a right to strike B. Right?
Yes, sir.
But if he were fearing for his safety and because of B's verbal assault, he thinks B is going to assault him, do you think he will have a right to strike B fearing for his own safety? I don't even want to use that word right, but do you think, let's use the word privilege. Do you think he will have a privilege, for example, to strike B fearing for his own safety?
I think he would, and I actually think it's a right, sir.
Okay, you believe that's a right?
Yes, sir.
Okay, why?
Why?
Because I don't know. I think this could fall under self-defense. If I'm scared that someone is about to hurt me, I think I also have the right to take a first action.
Supposing we also talk about
that
usually the principles of proportionality could come in.
Yes,
where
exactly.
someone says, well, he did not hit you. Why did you hit him? Why didn't you just verbally assault him too?
Sir.
Hello?
Hello, sir.
Okay, go on.
Okay, I don't agree with Jamaluddin because to my mind, it's just as you said, it is not proportional. It's just a verbal assault, and you cannot prove that the person wants to back that action. So you hitting the person as a right of first action, just like Jamal said, in that instance cannot amount to self-defense because it's not proportional. Yeah, the rule of proportionality cannot be met there.
I think that the rule of proportionality does not come into place now, because what exactly we are faced with is you defending yourself from an assault, a proposed assault. So yes, we know that it's not proportionate, and that's another issue entirely. But at first, I think that you have a right to defend yourself against any form of assault. That's what I'm saying. The rule of proportionality can come later, but
Okay,
at first, at best, you have a right to defend yourself against any assault.
Now, the beauty of this discussion is this. We were talking about context, right?
Yes, sir.
Now, we have had this whole discussion without anybody talking about context.
Sir, can I say something?
Okay.
I think, okay, speaking of context and speaking of the vagueness of the definition of terms, like now we are talking about, is it a privilege, is it a right? But we've not actually defined like privilege and defined right to determine whether within the context of this circumstance, it is a right or it is a privilege. So
Now,
for instance,
okay. Definition is another issue right now. Okay. Now, the definition will have to come within context too.
Yes.
Of whether something is a right. You can have a general definition, yes. But when we talk specifically about facts now, it always has to come within context. I'll give you an example of some of the discussions we're having now, why you can have where you can have some of these confusion. And confusion is normal in jurisprudence. Now, when we talk about A striking B fearing for his safety after a verbal assault, the question is, what laws exactly are we talking about? What is the context? If it were in Nigeria, you may be talking about, again, some of the issues relating to proportionality and all that stuff. But let me tell you this, in California, they have something that they call make my day law. Now, the phrase make my day comes from a movie starring somebody called Clint Eastwood, where he himself became something like a vigilante. when there was too much crime around the area he was living, he just took a gun and started shooting people that he thought were criminals. And before he shoots you, he will say, make my day. So the make my day law in California was basically to the effect that as long as you are in a location that is termed as your space, if somebody enters into that location and you fear for your safety, you can take a gun and shoot that person. So basically, that is what make my day law is. So now this question is a simple answer to question to answer if you are talking about Californian law, for example. But it's not so simple if you are talking about instances happening in a country like Nigeria or Britain, for example, or Britain. So two things are important, and I'm happy that you talked about that. Definition is important, but definition also has to come from context. When you are defining something, are you giving a general definition? Like when people talk generally about jurisprudence and they are giving a definition of what jurisprudence is, they basically talk about the definitions of Western scholars. And we all know that we have jurisprudence everywhere. We are beginning to understand what we call the African jurisprudence, where reconciliation is more important than sanctions. We are beginning to talk about jurisprudence. For example, there's Jewish jurisprudence, there's Islamic jurisprudence, there's Catholic jurisprudence, there's, based on certain philosophies. So now, the key thing is context. When you are defining anything, you have to give context to that definition. And the beauty of jurisprudence is, like Prof said that I think about 2 weeks ago, there is no yes or no answer to any question. I hope we are okay there.
Yes, sir.
Yes, sir.
Okay, so now, when we talk about one of the greatest inquiries that you have is when we talk about the nature of law, which we say was at first conceptualized by Plato and Aristotle. And we live with that statement but our understanding now is that these questions have been ongoing for centuries, probably centuries before Plato and Aristotle, but they were the first that made those inquiries popular. Now, we said they seem to embrace law from the precepts of not only enacted law, but that of prescriptions and customs. Why? Because Plato and Aristotle were seen sometimes as natural law scholars. And we know that natural law scholars were focused on things called natural law that was subservient to your reason, your logic. And we know one of the things that emanated from reason and logic of the general population in any place will be customary law and prescriptions. Now, most of the controversy about the meaning of law came to center around the distinction between law and morality, as well as whether there could be an objective analysis of what constituted both. Is it possible to have an objective analysis of law and morality? Just unmute and talk.
I don't think so.
Why?
Well, in my opinion, I don't know. I don't feel anything is objective, in my opinion, as a personal view.
If I had
I don't
money,
think
I'll send you a check.
anything. See, I always say this. I'm expecting to check one day.
Don't worry. You'll get it in the mail. Now, we use the word objective, but in our study of jurisprudence, there isn't any such thing as objective. we start from the premise of everything is subjective. That's your opinion, that's your perspective, that's your perception, that is how you view things, that's your worldview, that's your idea of law. And particularly as between law and morality, why? Because the two overlap. Some say morality gives law the impetus to be executed, and some think differently. Now, in terms of the relationship between the two, we have found out, we have discussed that we kind of look at morality as predating law. Because you think in terms of, okay, we have a sense of morality, our conscience, a sense of justice to do so and so. Then you cannot enact law on the basis of that so-called sense of morality. But one of the things you and I know is that morality changes from time to time. Morality doesn't stay the same. What was moral 20 years ago will be different today. My mother died about 30 years ago. If somebody just brought her alive now to see what's happening in terms of what is called morality and immorality, I think she will have a heart attack. Because the sense of morality then would have changed today. What is immoral today was what was called moral in those days, and vice versa. So because of that, everything changes, even in terms of what we call public policy. Public policy is one of those things that also has as morality as its basis. And you know, I think it was Richardson versus Melich, where it was said that whoever talks about public policy is an unruly horse that will drive you to nowhere. It will drive you to wherever it wants. So because of that, we also look at what is the consistency of things. So that when you give a label to something, you have to understand clearly what that label is. Now, we said some of the things, some of the differences between law and morality could be that we are talking about law now, that it is characteristic of law to be enacted. That question in itself is questionable. Can someone tell me why?
So what's the question?
One of the first things we are taking a look at in terms of the difference between law and morality was that someone says it is characteristic of law to be enacted. And I said, even that in itself is questionable. Is it not?
Yes, sir, it is. Because there are law, we cannot say law must be enacted because there are some places where the laws are unwritten. If we are talking about the pre-colonial era, when laws were largely unwritten, so I think that could be an exception, or some exception to that general statement.
Thank you very much. Again, to you too. If I had money, I would have sent you a check.
Also, the issue of customary law.
Okay.
The issues of customary law, where it emanates from the practices and customs of people. So it's not specifically enacted by some bodies. It's just in their day-to-day life.
Thank you very much. Thank you. That's exactly how I'll send you guys money. But I'm still waiting to have that money before I send it, before I start sending money to you guys. That is exactly how you question things in law. When someone, every time, you have to look at printed paper as questions, not as answers. When someone says it is characteristic of law to be enacted, I think your ears should stand up and you ask yourself, is it characteristic of law to be enacted? Of course, the sentence may say it is not absolute. We are just saying characteristic of. But you go to some places where the large chunk of the laws that they apply are actually customary laws rather than legislation. When last did any of you, and you are law students, when last did any of you read the legislation from page 1 to the last page? The Constitution is the
Maybe
mega
never.
statute for any country. And in Nigeria, we have the Constitution. As I speak to you, I do not even know how many pages the Nigerian Constitution is. I have not read it from page 1 to the last page. Who has done that?
Mayowa.
Now, I asked the same question, I think, about 1 or 2 years ago, and one student said he had done that, and we classified him a crazy person in the class. And I hope I don't see too many crazy people. But what we're trying to say basically is you have legislations that even if they exist, people do not have an awareness of. And I'm talking about even professionals, which is why you specialize. I specialize here, another person specializes there and all that. Now, if enactment is what characterizes law and morality, then there are also aspects of the law that lack of enactment can also characterize, such as obviously customary law and all that stuff. And then you can also have things relating to constitutional conventions, for example, that are actually enacted and so they are not justiciable. I hope we understand. So the key thing and what I implore us to do is to question things. Every sentence is questionable, which was why last week we were talking about the devil is in the detail. These are the details we were talking about where the devil resides. Now, another one says morality resides in the public domain. Law resides in the public domain, while morality is left in the dark recesses of the mind. Again, this is questionable.
Come again, sir.
You are seeing the slide. It says morality, I'll use the cursor on it now. It says law, okay? Law resides specifically in the public domain, while morality is left in the dark recesses of the mind. That is the point I'm making, is that is another questionable statement. And you must understand that law is filled with questionable statements. Every right thing you see is filled with questionable statements that require some level of inquiry, questioning. The next one says many rules of morality are not suitable to enforcement by what is called the rough engine of the law. But both do overlap, and therein lies the angle of inquiry. Most of the times when you are trying to inquire into something, it is where there's an overlap that you look at and you find that they are the easiest, more interesting areas to look at. Now, there's a distinction. We said there's a distinction. And why we are going big on morality here is because in terms of when you talk about law, morality is one of the bigger. We are not talking about religion. We are not talking about customs and all that. We want something that is general, something that can stand toe to toe with law in terms of a discussion. And we said the distinction between law and morality can permeate some indices of legal order. It means this distinction can permeate, it can go through indices of legal order. One is this: its foundation in public acceptance. Usually, the foundation of morality is in public acceptance, that the public generally accepts it as a rule of conduct that they follow. Not that anybody wrote any law somewhere, but it is seen as a rule of conduct and everybody follows it. That is not the same thing with law, for example, because I remember reading Professor Ijalaye when in Ondo State, they had this bush burning edict where they had this fantastic number of years for anybody that was caught burning bush. And the farmers, hunters, poor people and all that stuff during Harmattan season were burning bush like no man's business because people were looking for rats and rodents to cook to eat. Nobody made any law about enriching citizens, but they made laws about citizens not finding, for lack of a better word, protein to eat. So that is a law, but that was a law that was lacking public acceptance. Because even the police, I'm sure, never got one human being and they said, this is an accused person and we are bringing him in.
Oh, yeah. Okay, let's talk about.
He's back. He's back.
Hello?
Let's talk about the considered as power.
Please, the owner of the goat should just help us by muting himself.
Hello? Okay, so can we continue now?
Yeah.
Can you hear me? Can we continue?
We can hear you, sir.
Okay. Now, the now we said it's the first one of the things that permeate both is its foundation in public acceptance. Two, the manner of its construction and administration. Are you with me?
Yes, sir.
The manner of its construction and administration. What we said was that morality was in the dark recesses of the mind. Usually you do not have a police or an army or bailiffs or whatever to enforce and execute morality. But in terms of law, you have that's in place to enforce law. And in terms of its construction, we talked about if it's a legislation, a legislation could be a very easy way in terms of its being written to construct law. While its administration is also very simple and basic. But this is not the same thing with morality. And then three, its eternal purpose. When you look at the specific purpose of law, the purpose of law generally is different from the purpose of morality. Can someone give us an explanation of that? What is the purpose of law? What is the purpose of morality? The eternal purpose. Any answers?
That's what I do now. Purpose of law, purpose of right.
Are you with me? Yeah, Ola Olu.
Sir,
Are you hearing me?
I can hear you, sir.
Okay. I just want to make sure that I didn't suddenly go mute. Now, when we talk about the eternal purpose for law, for example, we can look at law and morality as some of the purposes for it to be to control society. An eternal purpose could also be to control society through, there are other ways that you can control society. You can control society not necessarily through law, but through dissemination of information, through media, through different sources. But one of the eternal purposes, the key difference in terms of eternal purpose between law and morality could be that when you follow the law, you are afraid of human and governmental sanctions. But when you follow morality, you are afraid of sanctions that may be divine. I hope you understand that.
Okay.
No, sir. No, sir.
What don't you understand now?
No, sir, I beg to differ.
Go on.
Yes, well, usually, most moral principles are based off religious principles or instructions. Not all moral principles are based, and could be from society. So, ostracization.
Am I the only one not hearing
Moral
you?
sanctions could be just similar to legal sanctions. You could be cast out of society. You could be. You could be.
Network is bad, Lord.
So in my opinion, some illnesses. Oh, okay.
Who had
My
clearly
point
what he
is,
said? Can someone else just tell me what he said?
Sometimes
I am having problems with hearing him.
To take a effect and actual legal sanction.
We are all having problems hearing you, sir.
You say what? Toby, you said something.
We are all having issues. Yes, sir, he's having network issues.
Okay. But let's continue. One of the things I think I got from him was to say that the eternal purpose, for example, in following morality does not necessarily have to come from religion, right?
Sir.
I hope I'm right. Hello.
In dictionary too. We can hear you, sir. Well, everybody
Okay,
mute
there
your
are
mic.
people that are talking on the. Let's concentrate on the lecture, please. Now,
sir, because
if that is what he said,
everybody.
I'm in complete agreement again with him, where he said morality doesn't necessarily have to come from a religious setting. So when someone is moral, it may not necessarily be that his eternal purpose is to go to heaven or go to hell, or as the case may be. And I'll give you an example just to punish and the point he's making. You have Bill Gates, for example. I think the founder of Mark Zuckerberg, the founder of Facebook, right? And they are all billionaires. You have Warren Buffett and people like that, and they all came together and they said, look, we are going to do what we call the billionaires pledge, which means that we are going to give 90% of our net worth when we die to charity for the purposes of taking care of the problems of the world, even long after we are dead. Now, for me, that is a moral imperative that they have submitted themselves to. But we also know that many of these people, Bill Gates, for example, is an atheist. Many of them do not believe in God. So if they do not believe in God, then it follows that they are not doing this because they think that somebody is going to punish them for something. And then they are using it to pacify that being so that they can be punished less or go to heaven or whatever it is. I hope you understand. But again, it could be a feeling that you get when you give money to a beggar, for example. Just doing something that you consider good can give you a feeling of self-worth, that you're a good human being, and it may end there, and it doesn't have anything to do with whether you're going to heaven or whether you're going to hell. So what he has also said is true. And basically what we want is to question things. Every sentence is questionable. So we said, if Lord, somebody said one person, I think they were interviewing another, of course, a billionaire. And he said, they asked him, they said, you have so much power. What do you want to do with this power? And he said, I don't have any power. If I had power, I'll be able to stop my wife from getting angry at me all the time. I'll be able to make my children have straight A's in school. These are the things that give me joy, and I do not have power over them. So I have absolutely no power. But everybody says the law is a power. Now, if the law is a power, it follows that that power must have some basic indicators. And some of the indicators people have said, and again, these are arguable, is number one, that there must be rules. That the laws must be enacted. And that enactment must be prospective in nature. I hope you're understanding. Nasrullah Ibrahim. But you're hearing me, right?
Yes, sir.
Okay, let me just go on there. Maybe towards the end of the lecture, we can have we can try to see if we can answer some of the questions. We said must be prospective in operation. What that means basically is you can't make a law. Of course, people have made it. It happened some years ago when there was a lot of cocaine trafficking in Nigeria, and the government wanted to stamp hard on.
So we cannot hear you again, no.
But can you hear me now? I'm back. I hope you can hear me now.
Yes, sir.
Okay, sorry, network. The time you were saying you couldn't hear me, and I was just blasting off. I think network went off here again. So we said if law is seen as a power, there must be rules. The rules must be enacted. That enactment must be prospective in operation. It means it should capture present maybe and future things definitely, not things that have happened in the past, because that is when law starts targeting specific citizens. And we said this has happened before in this country. Now, again, we talk about the law must be understandable. When you make legislations in English, for example, You now ask yourself, how many Nigerians understand English? And some of the provisions in chapter 2 actually talk about government having the power to make law in local languages for citizens. Now, other than that, we as lawyers, you've seen all the heretofore, hereunder, therein before, therein after, and all that. When you start having things like that, there is no simple language. If there's no simple language in lawmaking, are we making it understandable? No. Then we said governmental action must be consistent with sanctions as punishment or deterrent for contravention of the enacted rules. It means governmental action must be consistent. We talked about the plethora of pardons that Donald Trump did for people who actually got convicted for protecting him. And the question was asked, even though the president has the power of pardon, the way he has exercised that discretion, were they consistent with sanctions and punishment? This is government in action. Not protecting, they are not protecting people because the child has leukemia and is dying and the mother is in prison. They are saying, I am protecting you because you protected me. Another instance, and this happened in Nigeria some years back, I think that was the time during the Obasanjo regime. There was a so-called third-term agenda at the time. And then one of the people that they said headed the third-term agenda was Senator Arthur Nzeribe, who was supposedly a billionaire. And there were figures being touted around that those were the figures he took to be proposing a third-term agenda. And the man came out and he said, look, this kind of money you are calling is 10 kobo to me. Under no circumstances will I take such puny figure to do any such thing. I'm doing this because I believe in it. And to buttress that point, he caused to be published his accounts in Britain by a British accounting firm to show how rich he was and how he did not need your the something naira that was being rumored at the time. And the Code of Conduct Bureau took a look at that accounting firm's report and said, well, gentlemen, when you were giving us your filings, you didn't state all this there. And they put him before the Code of Conduct Tribunal. And what happened thereafter was the Attorney General came in and entered a nolli prosequi. The government is not interested in prosecuting this person. So you have instances like that all over. But all these are questions for law. And these questions, particularly after the 4-year Trump presidency, these questions are being asked more and more now about governmental actions and what the law is. I hope you are still with me.
Yes, sir.
Yes, sir.
Yes, sir.
Thank you. Now, again, like we said, if anybody has a question, at any time you can interject and ask the question, and we try to, we all try to address it and see how far we go with that. Now, we said there are some main areas of legal inquiry. And the first area of legal inquiry, when we say we are looking at, we've talked about what the nature of law is. Before we talked about the nature of, in talking about nature of law, we focused on law and morality and what differences there were. And what we ended up basically with talking about the components of, and when we talk about the components of law, your head also has to tell you that these are the components of legislation this lecturer is talking about, not the components of law. Why? Because the components of, if we are talking about the components of law, then we must include things such as customary law, which we have not done. we must include things perhaps such as aspects of canonical law or Islamic law, which wasn't done. I hope you understand that. So everything that is done is something that can be improved upon in terms of being more deliberate and then being more descriptive. And we say there are main areas of legal inquiry. When people are saying they want to study law, there are certain areas that they study. One of the areas is what you call the analytical matter. Okay, now the analytical matter consists of the study of infrastructure. That's how you analyze infrastructure. What are infrastructures? You have the judicial system. Okay, in having a judicial system, some of the other systems that function under that judicial system will be, for example, the Nigerian police, which is a system. You have the prison system, you have the law offices and all that stuff. Then again, you have subject matter. Subject matter could be anything. It could be any specific subject. It could be elections, the law of elections, or the law of gifts. And those are subject matters. Then legal precepts. Legal precepts will basically be concepts such as, like we treated now, right. Last week, Prof was talking to you people about possession, ownership, personality. And those are the analytical matters that you are focused on. Now, the sociological matter tells us to study law functionally. There's a sociological matter where you study law functionally as an instrument of social change. Now, if you look at law as an instrument of social change and you study it functionally, some of the things that helps you with is, especially for people that are living in developing countries, one of the things it helps you with is you start to look at law as an instrument of development rather than an instrument of just social control. And if you look at it from the perspective of an instrument of development, why? Because that is where your own continent suffers from. Then the way you interpret laws would be different.